Hello friends, today's topic is about Hindu Adoptions in Maintenance Act 1956. Adoption of any child, the procedure which has to be followed, or what are the rules that has to be followed while taking adoption or giving adoption as per Hindu Adoption Act, or in Hindu religion or in the Hindu subject. What are the rules that has to be followed while taking adoption or giving adoption? If a child is to be adopted, then what is the procedure that has to be followed? As per the Hindu Adoption Act 1956, the act says the adoption, how the adoption has to be taken place, or who can give adoption. Valid adoption requisition in there. Adopting has the capacity and also the right to take an adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption. The adoption may compliance with the other condition mentioned in this chapter as per 1956 Adoption Act. If a male person want to take adoption, then what is the rule? That is very much important. As per section 7, it says any male Hindu who is of sound mind and is not a minor has the capacity to take a son or a daughter in adoption. If he is already married, then he has to take consent of his wife. Without the consent of wife, he cannot take adoption. And this is about one wife. If a person is having two wives, then if a person has more than one wife living at the time of adoption, the consent of all the wives is necessary, unless the consent of any one of them is unnecessary for any of the reasons specified in the provision. That is very much important. And if a female want to take adoption, a lady, she want to take adoption of any child, that she should be of sound mind, not a minor, and she should not be not married woman. If married, whose marriage has been dissolved or whose husband is dead or has completely and finally renounced the world or has caused to be a Hindu or has been declared by a court competent jurisdiction to be sound mind. Section 8 says about if a lady want to take adoption of any child. This is very much important with regard to section 8. And section 9, person capable of giving in adoption. If someone want to give adoption, like father of the child whom anyone want to take adoption, the parents of the child, how they can give her children for adoption, or guardian want to give adoption of any child, who is a guardian to look after, whose parents are not there and guardian is looking after the child, whether he can give adoption of that particular child. Section 9 says, no person except the father or mother or the guardian of a child shall have the capacity to give the child in adoption. Provision 2 says, the father if alive shall alone have the right to give in adoption, but such right shall not be exercised save with the consent of the mother, unless the mother has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind. This is with regard to parents. Father want to give adoption. If mother want to give adoption, if the mother may give the child in adoption, if the father is dead or have completely finally renounced the world or so and has ceased to be a Hindu. So these two things will be same with regard to if a person want to give, male person want to give his child as adoption. This is the thing. If a female want to give her child to be for adoption, she has to be same provision and same condition is there. And with regard to if a guardian want to give the person under whose custody a lady or boy is, he want to give adoption of that particular child whose parents are not alive, then section 9 clause 4 says both the father and mother are dead or have completely renounced the world or abandoned the child, have been declared by the court of competent jurisdiction to be of sound mind, or whether the percentage of the child is not known, parentage. The guardian of the child may give the child in adoption with the previous permission of the court to any person, including the guardian himself. If the guardian want to give the child in adoption, he has to take permission of the court. If you want to give that child to adoption to any third person, he has to take permission of the court for giving adoption. And section clause 5 says, before granting permission to a guardian under subsection 4, the court shall be satisfied that the adoption will be for the welfare of the child, due consideration being of this purpose, given to wishes of the child, having regard to the age and understanding of the child, and that the application for permission has not received or agreed to receive, and no person has made or given any or agreed to make or give to the applicant any payment or so and so reward. This is very much important, that there should not be any money transaction between adoptive child or one who is taking adoption or person who is giving adoption. There is section 10 says who may be adopted, like a child who can be taken adopted. Section 10 says he or she has not been married unless there is a custom or usage applicable to the parties which permits person who are married being taken in adoption. So as per the law, if a Hindu can be taken adopted, and he should not be already adopted by anyone, and if a married person want to be get adopted, they should be accustomed to that effect, that the family or the Hindu family or to which he belongs, there is a custom that the married person can be taken into adoption, then the provision can be give permission for adoption. And another clause 4 says he or she has not completed the age of 15 years unless there is a custom or so and so applicable to the parties, completely age of 15 years. Above 15 years, there should be a custom. He should not be married or he is above 15 years. He can be adopted if the custom says like that. There is a custom between the parties. Otherwise, below 15 years, adoption is must. That is the rule of the law. Above 15 years, no adoption until there is a custom to that effect, custom or usage. This is very much important. Another clauses are that other condition for valid adoption by a female and the person to be adopted male, the adoptive mother is at least 21 years above. If a girl want to be adopted by a male person, his age should be about 25 years of the girl whom he is taking as adoptive. If a female want to take adoption of a boy, then her age should be about 25 years from the age of the adoptive boy. That the clause says. And if the adoption is of a daughter, the adoptive father whom so and so, daughter, son, daughter, by legitimate blood relation or living at the time of adoption. If the adoption is of a son, the adoptive father or the mother by whom the adoption is made must not have a son or sons living at the time of adoption. This is very much important. If a boy has to be taken into adoption, the person who is taking the adoption, he should not have a boy in his family to take adoption. If he is taking a female in adoption, there should not be a female person in the family whom he is taking adoption, the person who is taking adoption. And there is another clause which says, clause 5, the same child may not be adopted simultaneously by two or more persons. If a person should not be adopted by one or above one person simultaneously. And the child to be adopted must be actually given and taken adoption by the parents or guardian concerned or under their authority with intent to transfer the child from the family of its birth, or in the case adopted child or child whose parentage is not known, from the place or family where it has been brought up to the family of its adoptive family. And provide that the performance datta homam shall not be essential to the validity of an adoption. So with regard to presumption by the court, if a registered document is there with regard to adoption, what is the court, how it has to presume as per section 16? Whenever any document registered under any law for the time being in force is produced before any court to record an adoption made and is signed by the person giving, and the adoption has been taken the child in adoption, the court shall presume that the adoption has been made in compliance with the provision of the act until it is disproved. And these are how to take adoption and how to give adoption. And if a boy has to be taken adoption, what is the procedure that has to be followed? That they should not have another boy living in their family. Then a boy could not be taken into adoption. If an already existing girl is there in the family, the girl should not be taken into adoption. That is much more important in this word. And if a guardian want to give adoption, he has to take permission of the court for giving that child for adoption, guardian. And there is certain provision also with regard to adoption, that section 17 says no person shall receive or agree to receive any payment or other reward in consideration of adoption. When a person want to give adoption, or someone want to take adoption, there should not be a money transaction or money consideration should not be there with regard to that adoption. If such is there, then there is a punishment as per section 17 clause 2, which is punishable with imprisonment which may extend to 6 months or with fine or with both. No prosecution. This is very much important, that if someone is taking adoption by giving money or taking money, then he will be punished as per this provision for 6 months or fine or both. And for prosecuting such person who was involved in this as per section 17, there should be a sanction prior from prosecution from the state government, and after getting sanction only they can prosecute the person who did commit this crime as per section 17. So friends, today's topic is adoption, Hindu Adoption and Maintenance Act 1956. 1956 Adoption Act says that person the child whom the adoption has to be taken, he should be below 15 years, and if he is above 15 years, the custom should be there, custom and usage should be there, then only above 15 years adoption will be applicable. And the parents of the child who want to give adoption, they should be of sound mind, and if a male is giving his child in adoption, his wife, he should take permission from his wife and his family members. That is very much important. And no money transaction, remuneration or consideration amount should be there with regard to adoption by this act says. If someone gives amount with regard to taking, adopting or adopting any child, they will be prosecuted as per section 17, which is 6 months conviction and fine also, or both. And prior sanction of the government has to be obtained for prosecuting under this act. And very much important is that if a guardian want to give in adoption any child who is under his custody, he has to take permission of the court to give the child for adoption. This is the provision of law as per Hindu Act, the Hindu Adoption and Maintenance Act 1956. Thank you very much for watching this video. Thank you.